We will go on the record in the matter 26 CF 56, State of Wisconsin versus Cody Capistrant. The state appears through Assistant District Attorney Jose Vila in person. We have Amber Sherwood, Defense Counsel, in person. We do not have Ms. Capistrant due to matters arising off the record and other things involving Ms. Capistrant, her counsel, the state and corporation counsel. The court is waiving her appearance for today's purposes. The court did also receive a letter from counsel Sherwood raising competency. Therefore, the court is going to order a competency evaluation. And hopefully we can get that done as quickly as we practically can. I do believe we have another hearing in August.
August 3rd, Your Honor.
And what time, if you recall?
Yes, one moment. It is August 3rd at 9 a.m.
Let me go to August 3rd. All right, so August 3rd at 9 a.m. What I'm going to do is I'm actually going to set the criminal matter at 9 a.m. And for your knowledge and information, we're going to just push that other hearing down to 9:15.
Okay.
I can't call them together.
Right.
So we'll just have to have the criminal one here first because we don't know how long the other one's going to be. And then we'll proceed and go down to have that other hearing. Okay.
Perfect. And we still start at the 9 a.m.
Yes.
Okay.
Yes. Oh, well, yeah, we may be able to get the report by, no, we won't get the report by then. Just a status, just put a status. Sometimes we're getting the reports lickety split, but sometimes it takes a little bit longer.
I was hoping because she's currently in Amory in a facility that maybe it could help facilitate. We'll see.
I really hope so as well, but we'll see. So August 3rd, status at 9, then we'll move on to the confidential matter. All right, anything from the state?
No, Your Honor.
Anything else?
No, Your Honor.
All right, then we are adjourned. Thank you.
Thank you.
Ms. Sherwood, I do need to speak with you momentarily in the back.
Yes, Your Honor.
How you liking being the bailiff?
All right, so far.
Good.
Keep trying to make him cry.
I'm sure this is a better encounter than some of the previous issues we've had since you two were in the same room together on that side.
Oh,
Yeah.
that's right. That's right.
EMS had to be called.
Some lady started puking
Yeah.
right there.
Well, her blood sugar is, she absolutely should have been to the hospital. That was
Yeah.
not good.
I felt bad, but I was like, oh, I can get my work done while this is happening.
I was just,
All rise.
No, I understand. All right, thank you. You may be seated. Are we good? Should we just call it?
Your Honor, let's go on the record.
We will go on the record in the matter 26 CF 60, State of Wisconsin versus Timothy Mulroy. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. We do not have Mr. Mulroy. We're set today in this matter for preliminary hearing. Mr. Mulroy doesn't appear. This matter was scheduled on June 10th at his initial appearance. He was in court and provided the actual and oral notice of today's date and time. The weather is good, but I can't recall off the top of my head. I don't believe he has a driver's license. So what is the state requesting?
I would ask for a warrant, Your Honor.
Mr. Feliski, stand mute or make any argument?
Your Honor, I stand mute.
All right, the court will issue a warrant, $250 cash, only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned. Right, thank you.
Thanks.
Have a good day, Your Honor.
Thank you, you too. Twenty-six CF 86, 26 TR 427, State of Wisconsin versus Maurice Corbine. The state appears through Assistant District Attorney Jose Vila in person. Mr. Corbine appears in person with his counsel, Emma Hanu, by video conferencing. We're set here today in this matter for a preliminary hearing. However, Mr. Corbine, you're going to be waiving that hearing. Is that correct?
Yes, Your Honor.
I have in front of me a waiver of right to preliminary hearing document. Did your attorney go over that with you?
Yes, Your Honor.
Did she go over it thoroughly with you?
Yes.
Do you
Yes, Your-
understand it completely?
Yes, Your Honor.
Is that your signature on the bottom of the page?
Yes, Your Honor.
Do you understand that once you give up the right, it's forever and you can't get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
I'll find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Ms. Hanu, did you thoroughly go over that document with Mr. Corbine?
Your Honor, over the phone, I verbally went over what the document contains, and then I had my colleague, attorney Amber Sherwood, go down to the jail and go through it again in person with Mr. Corbine. So I am confident that he understands what a preliminary hearing is and that he would be waiving it knowingly, voluntarily, and intelligently.
Thank you, Ms. Hanu. Information?
Thank you, Your Honor. It has been filed and it mirrors the criminal complaint.
It mirrors the criminal complaint. Does he wish to move forward with his arraignment right now?
Your Honor, we would enter a not guilty but ask for 10 days to be preserved on pre-arraignment rights.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. 10 days granted. I have a motion to modify bond argument, Ms. Hanu.
Thank you, Your Honor. The court originally imposed a $5,000 cash bond in this. On June 28th, Mr. Corbine, pro se, sent a motion to the court requesting it be lowered to $3,000. Following my appointment, the court requested that I file a formal motion. I filed a formal motion requesting an amendment from the cash bond from $5,000 to $3,000. Since following that, although not in there, but relevant for the court, Mr. Corbine has informed me that upon his release, he intends to find AODA counseling and treatment. It just has not been finalized yet. I believe this is still a significant amount of cash that would ensure his appearance.
Mr. Vila?
The state has reviewed the motion filed by the defendant prior to getting counsel and by Ms. Hanu. Given that this was originally referred as a higher level OWI and he was actually charged out as an OWI 5 or 6, the state has no objections to reducing the cash to $3,000, same conditions.
All right, the court will amend the cash portion of the bail bond to $3,000, same conditions. All right,
Yes, yes, Your Honor.
we need a return date. Status conference, August 31st at 1.
Your Honor, I am in a trial that day.
September 1st at 1.
That would work for me.
Right, September 1st at 1. All right. We will see you then.
Thank you, Your
We
Honor.
are
Have a good
adjourned.
day.
You too. Miss Ingstrand? Did you apply for a public defender?
Last time I kind of misunderstood.
Oh, yeah, and there was an offer, I believe it was to
Yeah.
amend to simple possession for costs.
Correct, Your Honor.
Can I do that without a public defender?
Yeah, you can,
Yeah.
do- yeah, if that's what you
See, I
want
was,
to do.
there was too much going on at one time that I misunderstood.
If that is the case, may I release my witness?
You are released.
Thank you.
Thank you.
That's
We will go on the record in the matter 26 CF 48, 26 TR 297, State of Wisconsin versus Michelle Ingstrand. The state appears through Assistant District Attorney Jose Vila in person. We do have Ms. Ingstrand appearing in person without counsel. We were set today in this matter for a preliminary hearing. However, Ms. Ingstrand, you have thought about the state's offer of plead to an amended count of simple possession THC for costs only, and you wish to accept that. Is that correct?
Yes.
All right. Formal motion to amend count 1 down to a misdemeanor THC.
So made.
Ms. Ingstrand, do you understand that you have the right to an attorney? And that means that you would have the right to have an attorney who goes to law school to look at cases, to look at facts, to look at if there are any defenses or a lack of defenses, to negotiate with the state, to argue to the court and to a jury. Do you understand there's certain advantages to having a lawyer?
Yes.
And so there would be, the same is true opposite of those advantages, which would be disadvantages. Do you understand that?
Yeah.
And you wish to represent yourself?
Yes, please.
How old are you?
40.
Can you read, write? You understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Do you understand that you would be pleading guilty to a misdemeanor possession of THC with a recommendation of costs only from the state?
Yes.
Do you understand that you would have the right to a trial? You would have the right to have an attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You would be able to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around April 17, 2026, you possessed a substance. The substance was a controlled substance, THC, and you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or up to 6 months in the county jail or both?
Yes.
Do you also understand that there is a recommendation for costs only, but I'm not bound to follow that, meaning I could sentence you to the maximum penalty if I thought it was warranted?
Yes.
Are you admitting here today you in fact did possess THC
Yes.
and you knew it was THC?
Yes.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
You have any, so you have no questions and you're just ready to proceed and enter a plea?
Yeah.
As to count 1, amended possession of THC simple, a misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of misdemeanor THC. A judgment of conviction will be entered. The other TR matter will be dismissed and read in as well. Mr. Vila, argument, please.
Thank you, Your Honor. I believe cost is an appropriate disposition here. Ms. Engstrand came and she's wrapping this case up in an efficient manner. And given the fact that this is a THC level offense, I believe costs are more than appropriate as a sufficient deterrent for the future. Thank you.
Thank you. Ms. Engstrand, anything you want to say or you want to let me know?
No, thank you.
Okay, this is not a very serious matter. It's possession of THC. However, it's still illegal in Wisconsin. I don't see when it's going to be legal. If you want to do it, Great, grand, wonderful, but just go to any state that it's permitted and authorized and legal. Any state around Wisconsin, just not in Wisconsin. I believe you have some cash bond posted. Oh, sorry, I was looking at the wrong case.
Mhm.
Sorry, I was looking at a different case. I had that pulled up. You do not have any cash bond posted. Are you still in Lindbergh Circle?
Mailing, well, my kids live there.
Okay, so are you just you just go from place to place right now?
My mailing address is here.
Your what
My
address?
mailing address is the house,
Where would you like us to send mail?
to the public health. To, what do you call it? Down the hallway, the opposite side.
Clerk of courts?
Yes, please. No, not the clerk of courts.
Department of Health and Human Services?
Yeah. They take my mail.
You take your mail?
Yep, and I come here and get it.
Okay, well, I don't know if we can do that.
It is under there. It is under there as my mailing address, and then you should have it on file. That and the house that I stay at. on
I
Highway
just have
70.
Lindbergh Circle, but, well, does your telephone number end in 9103?
Nope.
Can I get an updated, please?
Wow. 715-475-8596.
Okay, that's important that we at least have that. May we send you text messages if we need to?
Yes.
Okay, now here's what I'm gonna do. It's very important that you make sure you make your payments. I'm only gonna assess $250. I'm waiving the rest of the court costs and fees. I don't think you are rolling in the dough, and I think that you're accepting the responsibility and you're being accountable and you're taking care of it very quickly. So that's why I'm waiving all other costs and fees. Are you currently working at all?
No.
So what I'm gonna order is, and this is, again, very important that you hear this and very important that you do this. I will allow you to make $25 a month payments, but if you don't do that, a warrant will be issued. You could sit up to 6 months in jail. 25 is the lowest I can go. And your first one's not gonna be due until the end of August. So hopefully you can figure it out. The
Mhm.
sooner you pay that off, the sooner you get me off your back, okay? Because the court can enter that civil judgment against you and a warrant. So it's very important that you do that. Otherwise, I will waive the remaining costs and fees, because again, you're stepping up. So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. When you're done here, you'll just go to the jail outside of the building, all the way around the back to the day reporting for the jail, provide your DNA. You have the right to request it be expunged through a written letter to the Department of Justice, not to the court, but to the Department of Justice, okay? I believe that covers everything. Mr. Vila.
I would agree, Your Honor.
Ms. Ingstrand, anything else you want to say?
No, thank you.
Okay, thank you.